Hello everyone, welcome back to my channel on Legacy Talk with Live a Home. And today with our special guest, Debbie, who is from Circular Law Chambers, and she will tell us more about what she does. And today's topic is actually very exciting. It's going to be the manner of holding that all of you has been questioning us, as well as trust, because we are starting to see a lot of people having a lot of interest on how can they actually purchase a property through trust, especially with the rising cost of property. So Debbie, can you tell us a bit more about yourself?
So thanks Kelly for having me here. I'm Debbie Brittany Lim. I am a partner from Circular Law Chambers. I actually specialize in real estate, conveyancing and legacy planning, which means that I actually work very closely with individuals and families on their most significant milestones in their lives. Yes, so that's about it.
So Debbie, you know, I've been doing this for the past 15 years, and recently, especially these 2 years, I'm beginning to observe that locations like River Valley start to take on more interested buyers who are buying under trust. Projects like Robertson Opus, projects like River Green, Zion Grand, and even recently River Modern. What's your take about it?
So actually, you are right that we do see a lot of clients still coming to us to purchase the newly launched properties under trust because they actually do see it as a great legacy planning tool for their children. We actually did some research to check how much it would cost for a child to be raised in Singapore. Surprisingly, can you guess how much it would cost?
I have 4 kids, so let me think about it. I have never really counted it. Probably $1 million or more than that.
Okay, so if you have 4 kids, you'll probably be spending around $4 million.
Yeah, right. I'm probably a multi-millionaire by now.
Each kid would be around $1 million. That's the reason why it's actually better in some way to invest in a property for their child at an early age, even before their child turns 21, because they believe that those other financial instruments, some universal life policies, for example, those you will only see the money when the parent dies.
Yeah.
But for property, you can manage it while you're still alive. And if you are able to rent it out, they would actually save this money so that they can actually use it to finance maybe their child's university fees. As you know, that is very expensive
Yes,
as well.
I know that.
Or just their child's daily needs as well.
Can you tell us a bit more based on your experience? What are the plus points about trust that you have observed? And the other side of it, which is the things that someone should look out for if they are thinking of buying a property under trust.
So I think the very first thing, which is the most important, is actually to ensure that you have the right intentions when you are actually entering into such an arrangement, meaning that you genuinely are approaching this because you want to have a good legacy planning tool in place for your child, that you are not doing this to avoid the payment of stamp duties or additional stamp duties. In the Stamp Duties Act, IRAS does actually look into this particular section 33A, which means that if there's any individual found to actually have entered into any arrangement or trust transaction even for the purposes of avoiding the payment of stamp duties, then you can actually get in trouble with IRAS for that.
So what will be the scenario where, let's say, someone buys a property under trust and eventually will not be able to claw back their stamp duty?
As you all know, to purchase a property in trust, there is a 65% ABSD payment that needs to be paid to IRAS. However, this 65% ABSD is actually refundable if they meet the conditions that IRAS has set out. Basically, some of the conditions is that you must have an identifiable beneficiary, meaning that you cannot put your future child, a child that is unborn, basically. It has to be alive already. Another condition is that you cannot include any clauses that allows the trustee to amend anything later on or to put any conditions attached to the trust. Like, for example, things like, I will set up this trust on the condition that my child sells it back to me at market value, or this trust will only go on if my child gives me a male heir when he turns 26, something like that.
Some conditions that you set in order to buy this property for your kid, something like that.
Correct. The most important thing is that the trust needs to be irrevocable. You cannot change your mind after. Basically, to put it simply, is that However, money you put down for this property for your child, you can say bye-bye to it.
Yeah.
Because it is your child's when you purchase it in trust for them, and it does not belong to you. So you cannot change your mind, even if, let's say, your child pisses you off and they fall into bad company, and then you get estranged. You cannot
Yes.
take that back. You cannot reverse it.
Which means if any one of you who are thinking of buying a property under trust and you have a lot of cash to use, I think the key is you need to accept that you give your child this property. Whether the child turns out good or not good, you just have to accept it and you can't call back the house.
Yeah, exactly.
And basically the child can only sell after 21 years old.
Before 21, you can actually sell this property as well, but it really depends how the trust deed is drafted. So we will always advise our clients to make sure that they get sound legal advice from a lawyer who actually is familiar with this area of law, because we have actually seen certain trust deeds that did not allow the trustee to sell the property before 21. After 21, the trustee actually has to ensure that the property is transferred to the beneficiary, and this would then be in the child's name. If, let's say, this child finds out that, I have this $2 million property,
Yeah.
the child can actually sell this property after 21 once it's transferred to his name, and he can use this $2 million to buy a car to get all the chicks that he wants.
That you want. Yeah. It's like boom, your 2 million is gone.
Yeah, basically.
And there's no way like the parent can sue the child in any way because this is how it's being drafted.
It's because the property belongs to the child, it belongs to the beneficiary, it doesn't belong to the parents, so it doesn't allow the trustee to do that.
So let's say, for example, earlier you mentioned that we know the educational costs and everything is increasing. Therefore, we want to in a way hedge against inflation, and all this money belongs to the kid. But let's say when the child becomes 21 and they want to sell off this property and we wanted it for the child's education. The child can decide that I don't want to use this for my education, I do whatever I want with it. So there's actually some risk that a parent needs to think about.
Yeah, what we always tell our clients is that make sure that you maintain good relationships with your child. Because we always warn them as well that after your child turns 21 and the property is transferred to his name, he can do whatever he wants with it. There's nothing you can do to stop him. So make sure that your child always listens to you even after 21.
This is the challenging part.
Yeah, make sure he's obedient and docile. Listens to the parent.
Very hard to tell these days, isn't
Yeah.
it? So let's say if the child says, when I'm 21, I started dating, and at the age of 24, I decide to get married. Does this actually takes away the child's right to ballot for a BTO?
Okay, so that's actually very interesting. They always ask the same question. Because their daughter or son might be below 21, so maybe 17, they always say that I don't know whether they will meet the right person in their 20s. What if they don't? How would the property be handled? Like, what if she wants to will the property to somebody else apart from them? What happens if they marry the wrong person?
Yeah.
This is a very valid question they will always ask. The thing is that it is their property. They can decide who they want to will it to after they're 21. They can also use it to stay with their boyfriend as well for their own occupation. Let's say if a positive scenario happens and they meet the right person and is accepted by the parents too, then this property will actually fall into their property count, so they will not be eligible to ballot for a HDB flat.
Which means to say that if I want to buy a property under trust for my kids, I also need to be mentally prepared that in the future, raise them well so that their income ceiling will exceed the BTO. And there's no way for them to get an EC either, that you just keep this property or sell it to upgrade.
Yeah, they have to sell it.
So the thing is, after they sell, then they wait for 30 months. By the time they are maybe 3 years old later, then plus construction another 3 more years and MOP for another 5 years. The child easily will have become 32 years old already. So might as well just buy privates and flip and upgrade from there, I guess.
Yeah.
So how often do you actually see that? Is it really true that the number of trust cases are increasing steadily over the years?
I'm not sure about increasing, but we definitely still handle trust cases every week. We do see a lot of Singaporean parents or even foreigners, if their children are Singaporean, they prefer to still keep investing in the Singapore property markets. Even if their parents are PR or a foreigner, if their child is a Singaporean, then they would actually tend to think about investing a property in Singapore for their child, because the stamp duties is based on the beneficiary's profile, not the trustees. So if their child is a Singaporean with no properties under his name, they will just pay the buyer's stamp duty plus the 65%.
Usually, is there an age that you observe like the parents start thinking about buying a property under trust?
Actually, not really. It's really about letting the clients know as well that if they purchase a property in trust for their kid when the kid's really young, they just need to ensure that they are ready to be able to manage the trust all the way for a longer period of time till it's 21. Yeah.
Is there any cost that one should cater for besides the fact that you need to pay your stamp duty and stuff like that? Any property management fees or any admin fees or whatever?
When you purchase a property in trust, the good thing is that the parent themselves are managing this trust, so you don't have to pay any third party like trust companies to manage. However, they do need to take note that for trust properties, IRAS will charge them the non-owner occupier property tax rate. So it's higher than the usual owner occupier rate. And the other thing is that they may actually not qualify for the child relief for income tax because their child will be deemed to have their own asset, their own property. If they're renting it out, then the child will have their own income, which also then leads to them taking note that they will also need to help the child file income tax as well.
Oh, wow, interesting. So means if the child is 10 years old and there's a 1.5 million property under the child's name, then there's income tax filing necessary?
Yes, yeah.
Oh, wow. Okay.
So there's extra homework for the parent.
Yeah. And what about if it's building under construction?
They would then need to ensure that the progress payments are met because it will be over a span of 3 to 5 years till the property is fully legally completed. They would then need to just ensure that every time the developer calls down for a payment, then they make the payment promptly.
So Debbie, I actually heard that in order to buy a property under trust, there are some preparation work to be done in advance. Recently, I have a case. It will likely take about 2 months in order to complete all the documentation prior to my client's purchase. What is your personal take about it?
Because I feel that trust is definitely a complex transaction. It's not something as straightforward as a regular purchase. It is advisable that you always approach a trusted legal advisor or lawyer to make sure that you are aware of all the implications, the risks, the consequences, advantages, disadvantages, how to even manage it as a trustee first before you actually start to go into the arrangement. And also because you need to be aware or advise properly on how to actually get your refund back as well, because we will need to apply for the refund with IRAS for the 65% ABSD because that's a huge sum of money that you don't want to lose.
Yes, absolutely. So in other words to say, if there's any of us or our own clients or even yourself as you're watching this podcast, you're considering to buy a property under trust and you really don't know how to go about, you know where to find us and you know where to find her. Our contacts will be actually below. You can actually click on the link below to check us out.